Hello, and welcome to this webinar titled How to Wind Up a Company under the Insolvency, England and Wales Rules 2016. In the course of this webinar, I will refer to those rules as the insolvency rules or simply as the new rules. My name is Stefan Ramel, and I am a barrister in full-time practice at Guildhall Chambers, and I practiced in insolvency and commercial law. Let me start with some basics. The new rules come into force on the 6th of April 2017, and they represent the single biggest change to procedure in insolvency proceedings for at least 40 years. The rules in relation to company winding up are now contained in a number of parts. So far as creditors' voluntary liquidation is concerned, those rules are contained in Part 6, and the rules on compulsory liquidation are contained in Part 7. And I propose to deal with both of those types of processes during the course of this webinar. I will start with compulsory liquidation processes. One of the major changes introduced by the new insolvency rules is the abolition of the prescribed forms which the old rules required to be used in insolvency proceedings. And that also applies to company liquidations. Now, so far as compulsory liquidations are concerned, in the week before the new rules were implemented, the court service has notified an intention to produce standard forms. Now, as at the date of recording this webinar, a number of those forms relate to compulsory liquidation, and they are as follows. There will be a form called SD1, which will be the form to be used for statutory demands, where a company owes a creditor a debt. There are then 7 forms, which are named Comp, COMP1 to Comp 7, which deal with the filings which are required in a compulsory liquidation case. Comp 1, for example, is the petition. Comp 2 is the verification of the petition. 3 is the certificate of compliance. 4 is the notice by persons of an intention to appear on the hearing of the petition. 5 is a list of appearances to be handed in at the hearing. 6 is a petition by a contributory, and 7 is a petition by an office holder. Now, so far as compulsory liquidation is concerned, the rules are organised in chapters. So Part 7 contains a Chapter 2 on statutory demands, and in that chapter you will find Rule 7.3, which sets out the long list of prescribed contents which must be in a statutory demand. Chapter 3 is then creditors' petitions. Chapter 4 deals with petitions by contributories or office holders. Now, a creditor looking to wind up a company, if using a statutory demand, must ensure that it contains all that is required by Rule 7.3. A petition which then follows also has fixed contents, and they are contained in Rule 7.5 in subparagraphs A to R. Now, in terms of those contents for both the statutory demand and the petition, there is not enormous amounts of difference between the position under the new rules and under the old rules, save for this, that of course under the old rules the form was prescribed, and so to some extent so were the contents, whereas they are not under the new rule, and so therefore the contents list seems much longer. Now, as I've alluded to by way of the court service forms, a winding up petition must be verified by a statement of truth, and that's governed by Rule 7.6. The simplest position is for that simply to be endorsed on the petition itself, and it doesn't have to be authenticated by the petitioner. It can be by somebody on behalf of the petitioner. But if that is the case, then the person authenticating it must state on what basis they are authorised and what the source of their knowledge is. In the same way that under the old rules, if a winding up petition came 4 months after the service of a statutory demand and an explanation had to be supplied, the new rules carry forward that requirement. Filing the petition at court is dealt with by Rule 7.7. The petition itself must of course be filed, A fee for presentation must be paid, which is currently £280, and there must also be a payment in respect of the official receiver's deposit. That is fixed not in the rules, but in the insolvency proceedings, brackets fees, close brackets order 2016, and that statutory instrument provides for a fee of £1,600. In the event that the company is in a CVA or an administration, the rules provide at Rule 7.8 for the petition to be filed in the court either which is governing the administration or in respect of which the court has jurisdiction for the CVA where reports have been filed by the supervisor. Now, of course, there are rules as regards the service on the company of a winding up petition, and they are to be found not in Part 7, but in Schedule 4, and in particular Paragraph 2 of Schedule 4. Paragraph 2, subparagraph 1, provides that the petition can be served by handing it to a director or other officer, or a person who, to the best of the petitioner's knowledge, is a director or other officer, or to a person who there and then accepts that they are authorised to receive service of the petition. If the requirements of subparagraph 2.1 cannot be met, then subparagraph 2.2 provides that the petition can be served by depositing it at or about the registered office in such a way that it is likely to come to the attention of a person attending the office. Finally, if none of the above is possible, then leaving it at the company's last known principal place of business or serving it on a director or secretary wherever that person is will also qualify as service. Now, service on the company is one thing. It may of course be necessary to serve on other parties, such as, for example, if the company is in a CVA, on the supervisor, or if the company is in administration, on the administrator, and if it's in administrative receivership, on the receiver. Of course, as with the old rules, the petition has to be notified in the London Gazette. The rules as regards that are contained in Rule 7.10. If it is a creditor's petition, the rules are that it must be gazetted not less than 7 days after service on the company and not less than 7 days before the hearing of the petition. After service has been effected and after the Gazette notice has gone out, it is necessary to file a certificate of service, a certificate of compliance, covering service and notification in the Gazette, and that certificate has to be filed not less than 5 days before the hearing. The rule which covers that is 7.12. It also requires that the date of the petition is specified, as is the date of service, as is the date of notification in the Gazette, and the notice in the Gazette must also be attached. As with the old rules, if the certificate of compliance provisions are not adhered to, it is a ground for dismissal of the petition. Now, notice by persons other than the petitioner that they intend to appear on the petition have to be served on the petitioning creditor by 4 p.m. on the business day before the day of the hearing of the petition, and the provision for that is Rule 7.14. The petitioner, as he had to before, still has to supply at court a list of appearances, and that's Rule 7.15. And the Insolvency Rules 2016 require the company, if it intends to oppose an application for compulsory liquidation, to file a witness statement in opposition 5 days before the date of the hearing. Now that covers compulsory liquidation. Let me now turn to creditors' voluntary liquidation. As was the position under the old rules, it is necessary for a statement of affairs to be prepared. Now, if it is a CVL which is being converted MVL, which has ceased to be solvent, and the statement of affairs is by the liquidator, the requirements are in Rule 6.2. If, on the other hand, it is a straight CVL which isn't preceded by an MVL, and the statement of affairs is by the directors, the new rule is 6.3. The statement of affairs prepared by the directors must be as at a date which is not more than 14 days from the date of the meeting. Rule 6.4 of the Insolvency Rules sets out the detailed requirements of a statement of affairs and also the contents of a statement of affairs. Predictably, of course, debts and assets must be listed. And in a change to the provision under the old rules, the list is much more extensive. A further new provision is the so-called statement of concurrence. That is introduced by Rule 6.5. This involves the office holder or proposed office holder giving notice to a director that that director is required to state whether or not they are in agreement with items in the statement of affairs, or whether they consider that the statement of affairs is erroneous or misleading. After receiving the relevant notice, the director has 5 days in which to return the statement of affairs duly annotated or with his comments marked. The directors are then required to give notice of their intention to appoint a liquidator and for the company to go into liquidation to creditors, either by the deemed consent procedure, which is a new procedure introduced by Part 15 of the new rules, or at a virtual meeting. The suggestion of a physical meeting does not appear in the rules. The relevant rule to look at for those requirements is Rule 6.14. Now, the decision date, if it is proceeding under the deemed consent procedure, must be not earlier than 3 days, but not later than 14 days from the date of the resolution to wind up the company. The directors, when sending out the notice, must also include the statement of affairs, and that is covered by Rule 6.14 sub-rule A. And that sub-rule also sets out additional notice requirements and contents for the directors to send out. If, for whatever reason, the deemed consent procedure cannot be used, and that may be because a sufficient number of creditors have objected to the use of that procedure, then the directors are required to call a physical meeting of creditors, and the provision which governs that is Rule 6.14 brackets 4. The decisions at the meeting of creditors are taken in accordance with the new decision-making procedures, but the reality is that majority vote rules, so the creditors with the largest debts will have the final say. Now that covers creditors' voluntary liquidations, and that covers both how companies go into compulsory liquidation and CVLs under the new rules. Thank you very much for listening.